What can you tell us about divisions of marital property? Who gets what? Is it 50-50 straight down the middle? How does this normally work out?
So I always say that one of the big jobs in a divorce is putting all the marital property into a bucket and figuring out how to divide that bucket, right? So one of the things might be if you had pre-existing assets, then that may not be considered marital property. So if I had a house going into the marriage, I get married, that house doesn't all of a sudden become marital property. But Massachusetts has a very liberal definition of marital property here where it can include pretty much anything in the divorce. So if I, using the example I just had, if I had a house that I brought into the marriage, but then it increased in value during the marriage or did improvements on it during the marriage, then that improvements and that increase in value is considered a marital asset. So even if the equity prior isn't, the equity during the marriage is. So even if people tell me all the time, well, I'm the only one that worked, it's in my name. That car is in my name. It doesn't matter whose name it's in. Your name could be on the deed to the house and your spouse's name could not be. Doesn't matter. That could be considered marital property. Same thing with cars, things like that. And also retirement accounts is another big one. So generally what you do is you look at what the value of your retirement account was at the time of the marriage and how much it's grown since then. And that growth is a marital asset too. But pretty much anything. I mean, even like patents can be considered a marital asset and things like that. And it doesn't matter whose name it's in. It doesn't matter who produced it. If it happened during the marriage, it's a marital asset.